A special circumstances hearing is something very important in a family law or divorce case, specifically in divorce case. According to Florida Statute 61075, that is Florida's equitable distribution statute. Think marital property, think marital assets and marital debts. You can have a special circumstances hearing if the marital home is in jeopardy. This is jeopardy. What kind of jeopardy are we talking about here? We are referring to a circumstance where your marital home might need to be sold immediately without even a hint of a delay. Such a circumstance might arise if your marital home is nearing foreclosure. If you are in forbearance and your forbearance period is about to expire. If you and your spouse are in massive debts and neither one of you can afford the maintenance and upkeep for the home. This might include a circumstance where the HOA is seeking a foreclosure. This might include a circumstance where your marital home is so far behind there's no chance of recovery, and even a short sale might be a blessing at that point, however unenviable that may be. To break this down further, you are now in a situation where your marital home is at risk of forbearance, foreclosure, or otherwise. This could again be because of the HOA, the mortgage lender, and there is such disharmony, distrust, and disrespect between yourself and your spouse that neither one of you either chooses to or literally can financially support the maintenance of your marital home. This is when you require a special circumstances hearing. You must convince the court not to wait 6 months for a mediation or a potential settlement, not to wait a year to 2 years for the entire case to go to trial, in which case all of the issues are decided by the judge, him or herself, and then there's a final order in which the home must be sold a short period of time thereafter. You are essentially asking the court to take an extraordinary measure to grant extraordinary relief in the interim, called interim partial equitable distribution of the marital home. You are asking the judge, the trier of fact, the court, to do something not normally done, to grant an extraordinary remedy, because to do the contrary would be to cause the parties to incur such financial distress, maybe even ruination, that there is no recovery from it. They might lose their home, their foreclosure. They might lose any equity they had in that home, and they might be in a terrible financial position that cannot be undone. And this may be simply a matter of the disharmony between the parties who, while going through a divorce, might want to have little or nothing to do with each other, even at their own peril and their own expense. This means you must have a well-written motion that clearly makes this case. An affidavit might be of some help, and you should bring enough evidence to cause the trier of fact to understand the situation and risk the potential for an interim interlocutory appeal, because to do anything other than to grant this relief would be to savage the parties, even if one of the parties protests for reasons that are beyond logic and reason, which is usually revenge, stubbornness, and divorce sickness. Let's admit to everybody and to each other that divorces cause a certain degree of psychological grief that may result in poor relations with your spouse and may result in decision-making that is guided by resentment and not logic and reason and the facts and the clear reality of a situation. Do your homework. Do your motion correctly. Make sure your evidence is assembled. Be prepared to prove, even if the standard is not beyond a reasonable doubt, this is special circumstances. So treat it as though that is the evidentiary standard, even if it's not officially framed that way. Convince the judge, get the relief you require, have your home sold, and start digging yourself out from this financial hole before it becomes a chasm and before everybody falls in and you cannot get out from underneath the financial pressure.